Hello. We are now going to speak about judgment, particularly the spelling of judgment. The judgment is the decision of a court on a particular matter or issue before the court. Now, the preferred spelling of judgment both in the United Kingdom and the United States is judgment. But if you look up the word judgment in any English language dictionary except for Black's Law Dictionary, there are two alternate spellings of judgment. Both are acceptable, but the second spelling, judgment, should not be used in legal English. There is some difference in usage between the term judgment in the United Kingdom and the term opinion in the United States. From the House of Lords in the United Kingdom, you would get a written judgment which would present the facts of the case and the court's rationale for reaching the judgment that they did reach on the particular matter. In the United States, the U.S. Supreme Court would issue a similar document, only it would be called an opinion, containing the same information, facts, rationale, and ultimately the judgment or the holding in the particular matter before the court. Duress, undue influence, termination and severability, costs and consideration. The first two are types of contract defenses. Defenses to a contract or defenses to contract formation. So what's the difference between duress and undue influence? Duress is when, if at the time of signing a contract or entering into an agreement, I'm under immediate physical threat or danger. Let's say an extreme example. Someone could hold a gun to my head and say, sign this contract. Under that situation, the contract is unenforceable and the defense would be duress. Undue influence would be where a professional abuses their professional relationship with me to persuade me to enter into a contract that otherwise no reasonable person would have entered into. That's undue influence. Termination and severability. Well, these are both two types of contract clauses. A termination clause is the clause in a contract which outlines the circumstances under which the contract will be terminated. Severability is rather different. Severability says that it's the clause which states that if for some reason one of the contract clauses, part of the contract is unenforceable, the rest of the contract still stands. So the rest of the contract will still be valid. Costs and consideration. Well, these are both to do with money. Consideration is what induces one party to enter into a contract, but usually, generally speaking, we are talking about money. And the consideration clause in the contract is the clause in the contract which details payment, the price of the contract. If for some reason this contract then goes to court, if there's a breach of the contract, if it's a subject of litigation, then one side is going to have to pay, and what they have to pay is costs, and costs refer to all legal fees that are incurred during a case. Hello back. Now we are going to speak about such dangerous and awful things that are homicide, murder, and manslaughter. Homicide is the umbrella term for other kinds of killings. Homicide only means killing. It describes various different killings, whether they are illegal or not. You are probably familiar with some of the words that end in "side", like suicide, killing yourself, patricide, killing your father, like the mythical Oedipus did, and infanticide, which means killing small infants. Often, homicide is committed in a completely legal way. For instance, the state of Texas, which has a death penalty. When they carry out this death penalty, it is a homicide although it is completely in accordance with the law. Murder is always intentional, and the kind of intention which is required by the law is called malice aforethought in legalese. It is the most serious of all the killing crimes, and there are several levels of murder. First, there is murder in the first degree, and that is committed when you kill a police officer or you commit the killing in an extremely cruel way where there's a lot of torture involved. Murder in the first degree can be punished by death penalty in the states where they have that, otherwise by long prison sentences. Then we have murder in the second degree, and that's just sort of the normal degree of killing, when you have just killed somebody but not in a terribly way, and that has a lighter punishment. Usually you don't receive the death penalty for that, and you don't have to spend your entire life in prison. Then we come to manslaughter, which is a lesser killing crime. To commit manslaughter you usually need an intent, but not an intent to kill. So, for instance, you can just intend to cause somebody physical harm. Let's say you stab them intending just to hurt them, but they happen to die. Similarly, if you have a reckless state of mind. For instance, you have a gun, you shoot it into a crowd, not really aiming at anybody, but the bullet hits somebody and the person happens to die. You can be convicted of manslaughter for that reckless act. There are also several fairly new kinds of crimes that are considered to be manslaughter. For instance, vehicular manslaughter, which occurs when you drive drunk and hit somebody and that person dies. You never had to intend to kill or to hurt anybody, but it just happened. You can be convicted of vehicular manslaughter.